Hello and welcome to Homeowner Talk. My name is David Stone and I'm the president of Nevada Association Services. And this is my co-host, John Leach, who's a partner in the law firm of Leach, Johnson, Song, and Gruco. Each episode we'll be here to talk with you about important homeowner topics, whether they involve homeowner association issues or homeowner maintenance problems. We, along with our guests, are here to provide you with useful information on these subjects.
We also want to encourage you to interact with us and our guests each episode, so please visit our website at homeownertalktv.com and send us your questions, and we'll try to answer as many of your questions as we can on the air and online. On this show, we're going to be speaking about conflict resolution for homeowners associations, and we're pleased to have joining us Lindsay Waite, the Ombudsman with the Nevada Real Estate Division, and Sonia Merriweather, the Program Officer for the Ombudsman's Office. And ladies, thank you so much for joining us.
Thank you.
Thank you.
Appreciate it.
Lindsay, we start with Lindsay. Do you want to just tell us about your background and what brought you to this position?
Okay, I'm from, I grew up in Baltimore, Maryland, and I went to college and law school there and practiced law from 1977 until 2004. I worked in private practice with Maryland State Government. I was an assistant attorney general, an administrative law judge, a public defender, and always loved the Southwest. So, you reach a point in your life where you decide to maybe make a change, and we moved here in 2004. Loved the area, and started out here with the Attorney General's office for a couple years as a researcher. I just didn't really want to practice law anymore, although I've maintained my license. And then the opportunity came at the Ombudsman's office, and it sounded interesting, and it wasn't the same as practicing law, but it still used my legal knowledge and skills. So.
And you've been now in this position how many years?
Since August of 2006.
Yeah, time flies, doesn't it?
4-year anniversary coming up.
Congratulations.
Sonia, could you tell our viewers a little bit about your background and the position you're in?
Sure. I'm originally from Knoxville, Tennessee. I graduated from the University of Tennessee, Knoxville, in 1984. My family and I moved to Las Vegas in 1996, where I started work with the state as a lost time claims adjuster. Started with the Real Estate Division in 2001. I currently hold the title of Program Officer, and I'm basically responsible for the HOA registration and the ADR program.
Excellent.
Wonderful.
So in that ADR program, is that also the program that Gordon Milden works in? Is that where they do the mandatory mediation or arbitration?
That is correct. That is the program.
Okay, great. Maybe let's start, Lindsay, a little bit with your office and the Ombudsman. Maybe you could help our viewers understand some of your, responsibilities or duties in the position, some of the things that you do to work with homeowners and board members alike.
Okay. It starts with the intervention affidavit process. I don't know if I should explain that in any detail.
Please, a little brief.
Sure.
Well, under NRS 116, if people have complaints in HOAs, they have an opportunity to put that complaint in writing. It's the intervention affidavit. And what the law requires is that you send to whoever your opposing person is by certified mail at least a summary of your complaints. The parties in HOAs, of course, are the homeowners, the board. And sometimes it's a neighbor-to-neighbor dispute. Sometimes there are vendor issues and tenant issues. What I see mostly are homeowners with concerns about their boards. So when they file the affidavit, it gets reviewed by our office carefully. We want to make sure there's been notice on the issues in the affidavit. Assuming there has been, I send a letter out summarizing the issues and inviting folks to meet with me, sometimes with me and a woman named Victoria Broadbent, who's another program officer. And if they're willing to come in, which they are about 25% of the time, we basically have what I call informal mediations. We facilitate the conversation. We try to get people to see each other's side sort of by summarizing what we're seeing, and help folks, we hope, to get beyond the personality issues, and a lot of times there's just a communication problem. And when people meet, about 50 to 60% of the time, problems are resolved. The folks that don't agree to meet, there's other review processes there in the office, and if they're not willing to meet, then we don't try to force them to meet.
And where does the intervention mediation take place?
It takes place in our offices where the real estate division is on Sahara and Eastern. And then for the Carson City folks, I go up there periodically. to our offices up there and have meetings up there with people. We sometimes do them by phone too if people are out of state, or we try to accommodate. If people agree to meet, sometimes I've driven to other areas like Pahrump and so forth too.
You mentioned that that a lot of it has to do with issues with the board. What other issues do you deal with, or do you see with the intervention affidavits? What are some of the common
kind of concerns? They range from governing document disputes, frequently in the fine context. I got a fine and I don't think it's fair. Some homeowners think that the boards are selectively enforcing the rules. They think they're the only ones that got the fine. There are homeowners that get concerned if a neighborhood is starting to deteriorate and not being maintained well. They'll challenge that and say the board's not living up to its fiduciary duty. We have serious concerns where there's charges of alleged financial misappropriation of funds, that sort of thing. Records is a big issue. The board won't give me the records I've requested or won't let me review records. Elections sometimes, technical issues about agendas sometimes. So it runs the gamut from governing doc issues, rules and reg issues, to serious allegations of violations of law or financial issues.
And I'm impressed that the percentage of time that these things resolve themselves when people are willing to sit around the table and chat and visit, try to understand what it is, 50 to 60%.
Yes, the success rate when they are willing to meet. And they're tough meetings. They last, I give them 90 minutes. I've had them last 3 hours. They can be very emotional sometimes too, I have to say, and difficult.
And if the parties are able to reach an agreement through the mediation in your office there, then what happens after that? Is the case then the affidavit itself is closed, or what are the homeowners notified, or the parties notified?
As you know, of course, if a board, because I make sure there's not a quorum of the board there, there's some few limited exceptions to that, to be honest, but the board member has to go back and get the rest of the board to agree to the proposed resolution. So there's a time lag sometimes of a few months. Sometimes, I know in one case it was almost a year. It had to do with the rental restrictions and a tenant and things like that, and time had to pass before that worked itself out. Where people don't agree to meet, yes. Files go directly to our compliance section. Those are our investigators, and they make determinations on whether or not there appears to be a violation of the statute, a violation of law. If they think there may be, they'll open a case to investigate. It doesn't mean there is one. It means they're looking into whether or not there is one. Easy example being, my board hasn't met for 2 years. Well, that's clearly a violation of statute. So if it's clearly governing documents, then they will write letters to the folks saying, we reviewed your file, you didn't want to meet. I mean, I'm paraphrasing. Your option is ADR. So if you want to pursue this further, you're going to have to go through the paid arbitration process.
What kind of process do you use for vetting? In other words, you can get a complaint. You take a specific type of complaint. If I live in a community association and I'm upset with my next door neighbor, that's not necessarily something that you would, barking dog, for example, that's not necessarily something that you would get involved, or is it? How do you determine what is subject to your oversight?
And I have to say, we have staff that try to refer folks to the appropriate resources, such as Neighborhood Justice Center, if it's clearly neighbor to neighbor. But you do have instances where neighbors detest each other, and one will, claim that the other one's violating the governing documents, or if it's a neighbor who's a board member, they'll claim that this board member is selectively harassing me, that sort of thing. But we do refer out to, we try to when we can to get folks in other arenas. If it's a criminal matter with serious threats to life or health or safety, we try to make sure people call the police right away. We don't want, so I think our staff is really good at referring folks to other resources where available.